start the recording, the transmission.
Okay.
Buenos días a todos.
Buenos días, good morning or good afternoon, wherever you stay. First, a small technical information to all our participants. To get a broader public, we will stream this on YouTube. Yeah, when you stay in the room, you agree automatically that you will appear, at least with your names here in YouTube. Okay. This is also maybe important for your questions, that we will hear or maybe read your questions in YouTube. You may give your questions later in Spanish, and we try to translate them together. But if you do them immediately in English, this is very fine also. So a very warm welcome. A very warm welcome to everybody. I have the great pleasure and honor today to introduce you to Professor Pfeiffer. Professor Pfeiffer will speak about the function of contract and property for the civil liberty. Professor Pfeiffer is actually the director of the Institute for Comparative Law, Conflict of Laws, and International Business Law. From 2007 to 2013, he was also the vice rector at the Heidelberg University. And from 2010, the first vice rector for international relations. So he's very important also for this international communication of the Heidelberg University and the law faculty. His university career as a student and PhD student, he started at Frankfurt Main, yeah, at Goethe University, where he did his doctorate in '86. He got his habilitation in '93 after a research time at Yale Law School. In '94, immediately he started at Bielefeld University, another important university in Germany, where he worked until 2002. During this time, he already got also a practical experience as judge in Hamm. This is very typical for German civil law professors, that they may part-time work as judges at higher courts as well. Then at 2002, he joined us at Heidelberg University. So he works at Heidelberg since 2002 as professor of civil law, international private law, comparative law, and international procedure law. He has a lot of publications in all of these areas, which I do not have time here to mention them all. Important maybe to mention is that he already worked as visiting professor in a lot of important institutions, like in Georgetown Law Center in Washington, in the Strauss Institute for International Dispute Resolution in California in 2014, in Leuven, and in Hong Kong City University in 2006. He received the Rio Branco Order of the Federal Republic of Brazil in 2015 and holds an honorary doctorate degree from the International Hellenic University. Further, he's member of the important German Council for International Private Law. And last but not least, Professor Pfeiffer is the German academic director of our international LL.M program here at the Heidelberg Center, which we do together with the University of Chile. So very welcome, Professor Pfeiffer. The floor is yours to talk to us about the function of contract and property for civil liberty. Thank you very much.
Yeah, thank you so much, Dr. Corzelius, for this very, very friendly introduction. Let me please add to the students and participants, it sounds much more than it actually is, but anyway, I'm very happy to be a part of this summer school. And by saying that, it is on the one hand obvious that I'd rather be in Santiago myself and meet you in person. But on the other hand, I'm also very happy that in spite of the very difficult circumstances, this summer school became possible. And this also makes me very happy, and I would like to express my thanks for that, particular to you, Dr. Recio, but also to you, Dr. Corsilius, and to all of the professors who take part in this summer school. As Dr. Corsilius already indicated, the subject of what I'm going to talk about is, or bears the heading, the function of contract and property for civil liberties. Initially, my talk was planned to be kind of an evening talk, which is a bit less formal than a classical lecture. And although we don't have evening yet in Germany, nor do we have evening in Santiago, I decided, also because of the topic, to present what I have to say in the way that I would also present an evening talk. So it is a little bit less formalized. I think that is quite appropriate for this subject, because what I'm going to talk about is rather something around the general topic of this summer school on the constitutional processes in Latin America. But in my view, it addresses some aspects that are very significant for constitutions to really work in everyday's life. Please allow me to begin with 3 observations. One of the most influential documents for the history of the Western Hemisphere is the United States Declaration of Independence from 1776. Of course, I could have also cited other documents, but I chose this one. And if you ever have taken a look into that document, you will find that it says that certain truths were held by the US independence movement to be self-evident, which is that every person is endowed with certain inalienable rights. And the wording of the Declaration of Independence enumerates the most important of these rights, and it refers in this respect to life, obviously, but also to liberty and property and the pursuit of happiness. And when you look at these inalienable rights, you will find that they have very much to do with you as a person, with your personal life. And that is, or can be seen as an indication that for personal freedom to really work, it is necessary that in particular, your personal life provides for circumstances that really allow you to shape your own free way of life. That was only one observation. Another observation is that one of the most influential books in legal philosophy Immanuel Kant's Metaphysics of Morals, which is a book on the very basic and fundamental insights for philosophy of law, quite tellingly, has two parts. One on the doctrine of laws, and the other on the doctrine of virtue, the doctrine of morals. And what is interesting is that the book does not begin with the virtue of morals, but with the virtue of law, the doctrine of law. And within the doctrine of law, it does not start with public law, not with how the state is organized, but with private law. What our private rights are, what we can claim in the relation of one person to the other. The first category that Kant addresses in this first part is the capability to desire. In other words, the capability to have personal and individual preferences. The fact that we all do have personal and individual preferences is, we can see that from these observations, is probably the most essential aspect why constitutions and working constitutional processes are so significant. The relevance of this category for legal purposes stems from the effects of legal rights, because what we have to understand is that legal rights enable us as a person to enforce what we desire regardless of the view of others. And that is what freedom eventually is all about. And as I said, I wanted to start with three observations, and my third observation is quite a different one. But it's also very important for understanding what contracts and property have to do with personal freedom. Imagine you have a car. Some of you will certainly have a car and own a car. You enter that car and you drive across the border to a neighboring state. What will happen to the property you have with regard to that car in this moment? I assume your answer, and please do not hesitate to ask questions or intervene at any time during my talk, or if you prefer to have that also at a later stage. What will happen to your property? Does any of one of you have an idea? It is a question that has to do with private international law, with conflict of laws. Is your property still your property after you have crossed the state borderline, the frontier, and are subject to the laws of another state, maybe? The usual answer that private international law will give you is that for property, we apply the law of the state or the jurisdiction where an object is located. That means, for instance, if you start out from Santiago and you drive, say, to Argentina, once you cross the border, the content and the effect of your property will all of a sudden no longer be governed by Chilean law, but by the laws of Argentina. And nonetheless, probably we all do have the understanding that your property is still the same, is your property. And that kind of indicates that the very idea of property is, of course, depending on certain state-made laws, but there is something about property that is pre-existing. And the effect may even more obvious if you look at the most personal contract you can have. What is the most personal contract you may have? Any suggestions? Any idea? What makes a contract a contract? In most legal systems, a contract is made a contract by the consent of two or more persons. So two or more persons have to say yes to something. And what is the most important situation where two persons have to say yes to something? Probably marriage. So marriage, of course, is a very, very particular contract, but it is still a contract because it depends on a formalized consent of the spouses. And what happens to your marriage if you move from one country to another? Well, that also depends on private international law. There may be some systems of private international law that apply the law of the citizenships. Other private international law systems, at least to a certain extent, apply the law of your permanent or actual residence, which means that the effect of your marriage, of that contract, may be very different if you move your residence from one country to another, and yet you will still probably regard the marriage to be the same marriage. So, and you can of course also find the same observation when you look at, for instance, business contracts. There are many cases where business contracts are executed without an agreement as to the applicable law in the moment of signing the contract, but where the parties agree on the applicable law at a later moment in time, and still it is the same contract. There are certain categories that seem to have an existence that is to a certain extent independent of the power of states and what the state wishes to impose on you. And we see from that contracts and property play a very essential role for our lives and for our ability to shape our lives in a sphere that is safe from intrusion by others. Yeah, that is one of the main results that I think are illustrated by these three observations. And what I would like to do with you is to elaborate a little bit more on this general idea I have concluded from and taken from these observations. One very significant aspect in this respect is that both contract and property are very closely related to certain general functions of the law. I don't know whether you have ever thought about the general functions of the law. What are the general functions of the law, in your view, in very abstract terms? What would you answer? Why do we have law? Why do we have law? Usually the very simple questions are the most difficult ones to answer, and probably the best answer to give on a very abstract level is to say that the law has two main functions. The first function is that we can rely on something. That, in particular, that we can rely on the effect that certain events in the past will have for the future. If I have bought a car, and if the property, the title to that car has been transferred to me, I would like to be in the position that I can rely on my property, that my expectation that now it's my car will be protected in the future. The same applies to contracts. Contract law and law in general, but also contract law, protects my expectation that the promise made by the other party to the contract will be kept and enforceable in the future. The protection of legitimate expectancies, legitimate expectations, that is one essential function of the law. And it goes without saying that protecting legitimate expectations is essential for being able to live my life as I would like to live it. Because only if I can, to a certain degree, plan and rely, will I be able to make decisions for my own. And only if I can make my own decisions, I'm really free. What is the other function of the law, by the way? Well, the other function of the law is to direct human behavior. Of course, to a certain extent, the state has to direct human behavior. We don't want a society where everybody kills each other. Would be bad for everyone, including the only survivor, because the only survivor would be rather alone and a poor person. So steering human behavior so that public goods are protected, that taxes are paid. We do have schools and universities. We avoid drunk driving or whatever. We don't kill each other. We don't steal from each other. Steering human behavior is the other function of the law. But when we look at these two functions, there is a certain tension between these two functions. On the one hand, protecting my legitimate expectancy is necessary to make me free. when I'm directed or steered by someone else, I'm of course not free. It is obvious that we cannot be free in every regard. We don't want people to be free to kill other people. So steering is necessary, but we have to have in mind that there is this tension between being free on the other and necessary directions, steering of human behavior by state and society. And contract and property have a very significant function for the first function of the law. Another aspect that you need to understand in this respect is that legal rights may have a positive and a negative direction. And in order to make use of rights, in most instances, both aspects are relevant. When, for instance, you look at property, my property, I can enjoy my property only if I can exclude others from using it. My apartment, my house is my house only if I'm the one who decides who may visit it. Some of you may have seen the famous movie Dr. Zhivago, based on the novel by Boris Pasternak. And the movie and also the novel plays at the time of the October Revolution in the Soviet Union. And it shows Dr. Zhivago and his wife living in their house. And one day, other inhabitants move in because the Council of Workers has decided. And then one day, the Committee of House Inhabitants decides that Dr. Zhivago and his family are confined to one room only. So only if my property is protected, I can make use of my property. That's the negative aspect. And the positive aspect is I can use my property only if I can transfer it to someone else. Very important. A further aspect that we need to understand is that in particular, private law rights have an important and play an important role with regard to enabling us to do something. Let's look at a contract. Imagine we all were living in the Stone Age, like Freddie Flintstone or whoever, and we want to exchange something we have, some rocks or whatever, or bones, with our neighbor. Of course, we and the neighbor promises to help us with the repair of a house or a cavern or whatever. And in exchange, we promise to give him some stones and bones. Of course, that could work also without any law in place. That is possible. So why is it that we need the law also for cases of contracts? We could have a rule that every person can keep their property even without a contract, and we could of course, have exchanges without a contract law. But what we cannot have without contract law is the following. What a contract allows me to do is to give my own statement legal effects. And that is an enormous power. Without contract law, I would not have that. Contract law enables me to give my promises, my signature, my statements a legal effect which they would not have without contract law. And that is what we call enabling function. Without contract and property, we could not make any promises. That is one very important teaching from all of that. Now, one last general distinction in order to also connect what I say a little bit more with the general subject of this summer school. Of course, you can address contract and property as law or parts of the law in private law, but you could also look at them from a constitutional viewpoint. There may be property, and there is property in a private law sense, mostly related to objects, whereas in a constitutional sense, it is possible that something qualifies as my property without having any physical substance. Most important example, the money you have on the bank account. So there is this distinction, and when you hear people talking, for instance, about property, you have to have in mind, or you have to always closely look what is meant in this moment. Does this person speak of property in the sense of a physical substance or intellectual property, or in a constitutional sense? That is not necessarily the same, although both are very important. Yeah. What I would like to do with you in the remaining time is firstly to look a little bit at contract law, and then also at property law, to add a little bit of specific aspects to what I have addressed so far. Why do we have freedom of contract as a general principle? Why do we have that? What is contract law necessary for? Probably the best answer is to say that freedom of contract is necessary for us to shape our personal lives freely. That would be the personal perspective, and also to have a society where transactions for the better of all of us are possible. And once we have understood that contract law is essential for shaping our personal lives freely, one further conclusion appears, and that is that, of course, in every society, you have different mechanisms in place for the distribution of goods or options to the members of a society. And the sphere where contracts determine what we have, by the same token, also defines the sphere of freedom and market as a mechanism for distributing goods. This, the sphere of freedom of contract defines where the members of society determine without intrusion of the state how goods are distributed. Maybe a few observations with in this respect. Observation number one. Until in former East Germany, the communist system in former East Germany, the German Civil Code, the Bürgerliches Gesetzbuch, BGB, applied until the early 70s. So formally, the BGB, with its freedom of contract principle, was still present in communist East Germany. However, the sphere where it actually played a role was very, very small. It applied only to a very narrow space, a very narrow category of transactions. Most transactions did not take place because the parties agreed so in a contract under the BGB, but because the 5-year plan of the communist government ordered business entities to undertake certain transactions. So the sphere of freedom of contract indicates the degree of freedom for the economy we have. So it is very, very significant in practice for how a society is organized. And please do not misunderstand me. When I'm saying that, I do not want to indicate that I think that everything should be based on contract. That is not what I want to say. The state will, and I will address that shortly later as well, there should be, of course, limits to the freedom of contract, but it is essential to understand that the limits to freedom of contract are at the same time limits to the freedom of society. Another example, for instance, relates to the National Socialist government in Germany in the 1930s and 40s, where it often happened that Jewish tenants had contracts with their landlord in relation to an apartment, but in spite of the contract, the landlord was by many courts allowed to evict Jewish tenants because the courts ruled that letting apartments to Jewish tenants will disturb the community of Germanic people in the house. It's another example of state intrusion into a contract, and it explains also that contract law is a very powerful tool to either make people free or do the opposite. And the same applies to property. Property is necessary for us to have a substance we can live on and we can dispose with. Property is necessary not only for our survival, we need food to eat, we need to have a roof above our heads. But also, if we want to take part in the transactions of a society, we need property. And therefore, as already the examples I gave you in relation to contract, it is essential for the freedom of a society that you have property. Only if you can have property, and only to the degree you can have property, you are free to do things you want to do. Of course, by no means I think that this freedom should be without limits. We do not want private persons to have tanks with cannons to shoot at the houses and destroy the houses of others. We think that this power should be limited to state forces. But nonetheless, property is necessary. It relates to very ancient ideas like, I may keep what I myself have created. I may keep what is owned by no one, unappropriated goods, and I may occupy them. That's a very deep-rooted attitude. And property, however, only functions if very different aspects of property work. And if you look around on a comparative legal basis, you find that property usually includes several aspects, and only these aspects together shape and are in line with the idea of what we call property. And let me shortly address these aspects. The first certainly is the right to possess. I may possess, I may actually have something that is my property. If that is my glass of water, it's my glass. I may have it. I decide whether I hold it in my hand or not. I have the right to possess it. And the next is, I may use it, fill water in or not, or fill whatever drink you like. Maybe not maybe in the morning you prefer to have coffee in it. At night, maybe a cocktail or a glass of beer or wine or whatever you like. Then you can do with your glass, you can use it. Nobody else can deny your right to use that. The next right is the right to manage it, which means I decide whether my friend may use this glass as my guest, or whether this is my personal favorite glass that only I may use and nobody else may touch it. I have the right to manage it. And if it is a very nice glass, I may even ask others to pay for using it for a day. May happen. Not so often with glasses where you can, simple glasses where you put your water in, but maybe if you have a nice car, a stretch limo that is rented for a day by persons who would like to have the fun of driving in a stretch limo. And very closely connected with that is another right, the right to draw the income of the good. In societies which neglect or deny property, it's very typical that you may not use your property to create income. Free societies allow that. Of course, there may be limits to that, but the right to draw the income from the property is essential. It's also essential because that allows me and indicates to me which kind of use is probably the best. If someone else is willing to pay me, say, 100 euros for using my property, I have to decide, is it more worth for me to use it myself, or more or better for me to get the 100 euros? Another aspect is the right to consume or destroy. The water in the glass is my water only if I can drink it. And if I'm angry because the TV program is so bad, I might take my TV and throw it out of the window as a just punishment for the bad TV. That's my right. I have worked for it. I have to bear the consequences. I can destroy it. Of course, I may not throw it on the cars of others because that would harm them. And if there are electronic parts, they must be disposed of so that no damage for the environment occurs, but I may destroy my goods. And I may also modify them. There's a famous anecdote that the well-known German painter Max Beckmann was one day visited by a young artist, and he presented him 3 paintings and asked him what Max Beckmann would pay for these paintings. And Max Beckmann answered, well, 20 marks. And the young painter said, well, I have had expenses already in the amount of 30 marks. Yeah. And Max Beckmann answered, well, that was when everything was new and not wasted with paint. So you can do with your property whatever you want. You can repair it, you can destroy it, you can modify it, you can paint it. If you like to have your car blue instead of white, you can do it. You can modify your property. You can alienate it, you can sell it. Very essential, and that is one aspect that is very close to constitutional aspects, the right to security. Of course, many states employ in certain cases a right of eminent domain. If a certain piece of land is needed for the public good, it may, under circumstances, be taken from the owner, but in general, we should be safe that the state does not take away what we have, right to security, right against expropriation, if you would like to say so. Then we have, very important for many people, the right to pass on our goods to our heirs. There may be, and now I get to the limiting aspects. They are also very important. Maybe one positive aspect: property is characterized typically by the absence of a termination. If I own something today, I do own it forever, if it's really property. It's not that I own property only for 20 years and then it's automatically forfeited or gone. But as I said, there are also limits. And these limits typically apply to both contracts and property. Some of these limits, at least. And the first is the prohibition of harm. I may not conclude and enter into a contract that either harms in an unacceptable way the other party. To give a very simple example, a contract where the other party agrees to be the slave of the first party would be unacceptable. And it would, of course, also be unacceptable to conclude a contract to unacceptable harm to others. A gangster hires a hitman to kill a third person against the salary of 10,000 euros or dollars or whatever. That contract would be illegal and invalid because a third person is harmed. The same would apply to contracts that are not in line with the public good. For instance, a contract to dispose of waste illegally. We cannot accept that. And one of the most difficult examples is that we do not accept certain contracts because their imbalance is outrageous. We do not accept, say, a loan contract where a loan shark offers to lend me money against an interest rate of, say, 100% per day. We do not accept that because that is, most legal systems do not do that, because that somehow indicates that there is something wrong with the underlying consent. We definitely, and all legal systems have that, we need certain measures in place that consent is given freely and that it is effective only if it is actually and indeed given freely. Yeah, ladies and gentlemen, I could continue that endlessly because, of course, the limits to freedom of contract and the limits to freedom of property are one of the most difficult, one of the most complicated issues for law in general. But what we need to understand is that contract and property are necessary to live freely, that the extent we can make use of these categories and institutions indirectly define the degree of freedom we have in a state, in a society, that on the other hand, we need limits, but that these limits are always connected and bring about a limit to our freedoms that may be necessary. And what we should not do is to opt for a black and white world where either you have 100% or 100%. What law really is about is to find the right way so that everybody's interest is part of the solution. And we also have to have in mind that all limits to our properties and to our freedoms in a free society are not the rule. And although they have to exist, are an exception that needs a justification. Yeah, ladies and gentlemen, that was my planned evening speech today given in the morning. And I'm happy to hear any questions or comments if you have questions or comments. Thank you so much.
Yeah, thank you very much, Professor Pfeiffer, for your inspiring ideas and for the nice, loose-knit form. I think this was very nice like this. Professor Pfeiffer himself already invited you. I only may repeat his own words. Questions and commentaries, please. Do we have the first questions?
I have a
yes.
question.
Andrea, please go ahead.
Yeah, good morning. Yes, my question is regarding the, well, in Mexico, we have some enterprises, foreign enterprises that come. And for example, well, I have an example of a community in Oaxaca that was moved. They didn't do it only because they wanted to do it. It was because some enterprises, foreign enterprises, came and used sorry, I don't remember the word in English for invadir.
Invade, the same. Invade.
Yeah, they invaded in some way the space of the community, so the community couldn't do their activities, their economy activities normally, so they moved. I don't know if that has something to do with private property, because they didn't force the community to move, but they left their houses because they couldn't use them as they regularly do.
Yeah,
it's
a very
interesting case.
Difficult to comment on that because I did not understand from your question by which means did these companies bring the people to leaving their houses. I mean, you said they invaded a certain community or village. What does that mean? Did they send their private troops so that nobody could do anything, or what did they actually do?
They used land near their land for wind energy, to produce wind energy. And they said that this affected their economy activities.
And how so?
Well, I don't know exactly, but they mentioned, the community, the people there mentioned they were so near that they couldn't work properly.
Yeah, so I understand now from your question that this company construed or established wind energy power plants very close to the community, so that, or to a village or a town, small town, so that people felt disturbed by and felt that they could not live there any longer because of that intrusion. Is that a right understanding? Yeah,
yeah.
It is very difficult to for me to comment that, because of course I do not know what the legal framework for such a situation in Mexico or in that state of Mexico actually was. In general, of course, there are several aspects that one should have in mind. Firstly, as I said, all private rights do have a negative effect. I need some protection against disturbance of these rights. That does not have to be perfect protection, but appropriate protection. For instance, assume you live in an apartment, in a house with a multitude of apartments. Probably it could annoy you if one of the persons there would play the piano very loudly. On the other hand, it is not inappropriate to play piano in a private apartment. So probably in such a situation where you do have the positive aspect of liberty, I'd like to play the piano, and the negative, I don't like that kind of music, have somehow to be balanced. And the question, obviously, in your case is, was the balance found in that case? Was that the right one? Should there be a law that wind energy plants need to have a certain distance to private houses, to private homes? Probably that would be a good idea to have, but I don't know whether the laws applicable in that situation had that. I think it would be appropriate to have constitutional protection against indirect expropriation in such a situation, unless it is accompanied by appropriate compensation and fairness and procedural guarantees so that the owners can make use of their rights.
Yes, well, what I read in the news is that they were permitted to be just 2 kilometers, well, no closer than 2 kilometers from the houses, but I think they were closer than that. So in that case, they are not respecting private law or private.
So the company did something illegal. So which would probably mean the problem in that case was not the problem of having the right law, but of enforcing it. But it certainly demonstrates the function of the law. A very important function of the law is to protect people against injustice by stronger people. Law is a means also for the defense of people against stronger people who would like to impose something on them. However, that obviously requires that the law is also enforced.
Okay, thank you.
Thank you from my side as well. We have some more questions in the pipeline. I want to pass the word to Luis Felipe. Luis, por favor.
Hi, Professor. Sorry about my camera. Professor, thank you for your lecture. It was enlightening. My question is, do you believe that the expansion of the idea of sustainable development at a transnational level will inevitably have to go through an ontological reformulation of the concept of property, or an intensification of the idea of the social function of the contract? I ask this because the deforestation in the Brazilian Amazon, some landlords who own the property title, they understand that they can do this because of that, because they own the property title. And even those who do not have the title of property, but only the possession, they understand that they can do it too. So my question is, if we want to increase this idea of sustainable development at a transnational level, getting the influence of the international level at our domestic level, if we want to do it, I would like to know if, in the professional perspective, if we have to go through a transformation of this classic concept of property and the intensification of this idea of social function of the contract. I would like to know what the perspective of the professor.
Yeah. Maybe two short answers. of course, sustainable development is in today's world a very significant goal. The question, however, is what is the right way to achieve sustainable development? For instance, when you look at destruction of rainforest in the tropical regions of the world, different answers could be possible. Of course, you could take away the property from the owner. Another way would be to enact, and even more importantly, also enforce laws that give a certain degree of protection to rainforest areas by making it illegal to burn them down. That could be done without changing the traditional understanding of property, just like it is illegal to undertake other activities that have a harmful effect on a public good. And personally, when it comes to categories such as the social function of the contract, I'm a bit skeptical. Of course, contracts do have a function that goes beyond the two individual parties. As it happens, a former doctorate student of mine, Professor Geralda Viviane Ferreira-Meche, has written her doctorate on the social function of the contract under the Brazilian Civil Code. However, it was written in German. I don't know whether you can write German. Her conclusion was that under Brazilian law, the category of social function includes very different aspects of contract law, and that it is helpful to distinguish these different aspects carefully. Probably she understands more of Brazilian law than I do, so I refer you to her book on the social function of the contract under Brazilian law.
Thank you very much. I see the hand of João Victor. João Victor, because you are Brazilian, you wanted to intervene exactly to this question or to want to give it a new direction?
Thank you, Sven. Yes, I'd like to jump in this discussion because I think it's the, and here, sorry for, I want to just register my cynical skepticism about all these theories that we are like thinking as we were medieval friends, right? So like people can use books to defend the relation between property and freedom. And my question goes focus on impact, right? So people write books like an artifact, like an exhibition, artifact of exhibition, like look all these books about property that we have. But when we go and we see what's the impact of this in realities as South America, and then comes this panacea of the function, the social function of the property, that doesn't work in Brazil, right? But okay, so I just, but before I complement my intervention, I would like to say that before anyone some idiot says that, oh, but he's a Marxist. I'm not a Marxist. I'm just saying that when I go to the field and I observe that in a country like, in a continent like Latin America, people try in Chile. Chile is my medieval friends. I'm studying the constituent process in Chile. So, but when we go to the field and the south of Chile, and we observe the water property rights, for example, we see, or if we go to a favela in Brazil, we see that property gives no liberty to anyone. Come on, who believes in it? All right, who believes in it? Yeah. Maybe, okay, just let me finish, because we see that the struggle here is not for property. The struggle here is against housing, living conditions, right? People live in structural conditions in which this idea of private property means invasion for indigenous people. For example, the property system for indigenous people in Latin America means invasion, means plunder of their natural resources. So I just want to register my skeptical cynicism, and thank you very much.
Thank you as well for this remark. Of course, everybody in the audience would probably know the situation in Latin America better than I do, so I don't feel myself in a position to comment on any particular aspect of that. A very general remark, however, would be there is always the difference between law in the books and law in action. Of course, the law in the books only works when the law in action is in line with the law in the books, which essentially depends on the fact that people really believe that the law is binding and that there is a culture that it is binding. That I learned when I first visited the Egyptian capital city, Cairo, where they had traffic lights, but no car driver ever looked at any traffic light. So because nobody believed that they have any binding force. And but let me add one remark in relation to indigenous people. If you say property means plunder to them, that may very well be right, I don't know. However, but what I know is if plunder actually can take place, it probably also has to do with the fact that they do not have property. Had they property and enforceable property, they would be protected. Every legal system that is built on property and contract in private life, of course, implies that we all can have it, and that nobody can takes it away from us. Maybe that is also a line of thought that one should have in mind.
Thank you very much. I have one more question here from Charlie. Charlie, ¿estás?
Sven, I think Shirley is in Puerto Rico and doesn't have a very stable connection, and that's why she wrote.
Maybe I read it out for you then. She thanks the professor and she asks if what rights especially, or what problems could cause what you talked about for her as an exchange student in Germany. She's talking about contracts, liberties, and other possibility if she's not a citizen, if she has to fight with some limitations because of that.
Under general contract law, citizenship is not relevant for your ability to conclude, to execute, to sign valid and enforceable contracts, and also for your position to acquire property. So in general, the answer would be with regard to contract and property, everybody should be and is equal. Let me make one remark in that respect. One of the historical documents I did not mention, of which I also had thought, was the French Code Napoleon, the French Civil Code. It is not by accident that the French Revolution, as a main effect, resulted in the enactment of a civil code, because prior to that, everything was based on usage, on tradition, and so on. You automatically had the same profession as your parents. You had to marry the person selected by your parents. If you were born as a craftsman, the only thing you could do is be a craftsman. And it was the big achievement of enlightenment and in France of the of the revolution, that after that, everybody was in a position to decide freely what to do. Not your status, but your decision to enter or not enter a contract decided on what you did. That does not mean that we don't need to look at obstacles to our freedoms. That is clear, but it was a dramatic change even then, and the ability for everyone to enter into contracts and to have property still, I think, is essential. And in Germany, as in most other countries, these rights should not, and in most countries do not, depend on citizenship. That is, in some countries, it's different with regard to real estate, but in general, not in Germany.
Charlie told me that her microphone now works and she has connection. She wants maybe to ask a little bit more in this direction. Charlie, now it's your turn.
You so much. I was thinking when I wrote these questions, I was thinking that, for example, in Cuba, if you are a foreigner, you don't have rights. So you cannot buy a house, you cannot have a bank account. And when I was in Germany, I noticed that at least you can have, of course, a bank account. But I was thinking that if you want to buy a house, if that could be possible, for example. Also, you can rent an apartment or in a house. That's not a problem. But in Cuba, yes, it's a problem because you don't have any rights. You must to be married with a Cuban, at least for have some possibilities or some freedoms in Cuba. But even you cannot buy a house. That's why I was asking you this question.
Yeah, thank you for that question. And that indicates, and the answer you gave yourself indicates that there are problems with certain freedoms and certain liberties in Cuba. Yeah, that's certainly the case. I think, unfortunately, I have to prepare for my next obligation. So if there's one more question, I would answer it, but otherwise, I would like to thank you for your questions.
Yeah, because we run out of time, really. I think we give the professor the time he needs. And thank you very much. I think especially this last part with this interaction and the debate was very, very inspiring. So thank you very much also to our participants for your really interesting cases and questions you put forward. Thank you very much again to Professor Pfeiffer and to our organizers. And I wish you a very nice continuation of this summer school. Thank you, everybody, and goodbye.
Thank you and goodbye.
Vielen Dank nochmals. That was also very accessible. very accessible, taking into account that some of our participants are not lawyers. So thanks again, Professor Pfeiffer. We enjoyed it.
My pleasure. Thanks to
Have a
you
nice
for
day.
organizing everything, and thanks to you also for acting as a moderator.
Yes,
And bye to
vielen
you,
Dank.
and thanks for the questions.
Bye.
Bueno,
Hola.
tomo
Aquí,
la
ya.
palabra para la organización de lo que viene ahora. Tenemos una pausa. Entonces, dado la hora y todo, yo creo que podemos tomar una pausa hasta las 11, ¿cierto, Inés? ¿Sí?
Sí,
Entonces,
perfecto. Sí, sí.
nos vemos de
El
vuelta.
día es largo hoy.
Sí, nos vemos de vuelta aquí a las 11 en esta misma sala.
Hasta luego, gracias.
Gracias.
Ok, muchas gracias.
Gracias.
Nos vemos.
Nos vemos. Chao, gracias.
Chao, gracias.